Hello, I'm Advocate Nikita Pandit and I will be speaking about the protection of plant varieties and farmers' rights under intellectual property rights, and you're watching Legal Bites. Agriculture plays a very important role in the gross domestic product of India, it being a major occupation of the population here. There has been quite development in agricultural sector with the Green Revolution, which was increasing production of seeds and foods. White Revolution for the milk production, Yellow Revolution for the oil seeds, and Blue Revolution for the marine production. Agriculture has contributed to the food security, provided employment in the rural areas, helped in managing the resources, and in protecting the livelihood of the people. Farmers and plant breeders play a very important role in conservation, improvisation, and making available the plant varieties. In such a case, it is important to have a framework to protect the plant varieties and the rights of the farmers and plant breeders to increase the investment in the research and development for the betterment of agricultural sector. India became a signatory to the trade-related aspects of Intellectual Property Rights Agreement, that is TRIPS Agreement, and in accordance with the Article 27 of Part 2 of the agreement, the Protection of Plant Varieties and Farmers' Rights Act 2001 was passed in India for protecting the plant varieties. Under this act, the breeder, his successor, farmer who cultivates the crops by himself or by supervising others, or the farmer who conserves or preserves the wild or traditional varieties or adds value to them by selecting and recognizing their useful characteristics, or association of farmers such as a group or a community, a university, or a public agricultural institution are the entities who can apply for the registration as per Section 16. Section 2C explains who is the breeder. Breeder can be an individual or a group of farmers or an institution who has bred, that is, caused the production in a controlled and managed atmosphere, evolved or developed any variety. What is a variety? As per Section 2ZA, variety includes plants except the microorganisms. These are the ones which come under single botanical taxon of the lowest known rank. That means which is a grouping unit where they are grouped based on the characteristics or genotype, that is its genes, and also based on its capability of not changing its characteristics after the breeding, that is propagation. These taxon are also given rankings. The propagating material is also included in this definition, which includes plants, its parts, seeds. It also includes extant variety, transgenic variety, farmer's variety, and derived variety. Extant variety as per Section 2J means the one which is mentioned in Section 5 of the Seeds Act 1966, where the central government notifies that a particular seed is to be regulated for selling it for the agricultural purpose. Seed as per Section 2X of the Plant Varieties and Farmers' Rights Act is a type of embryo which is the development after fertilization, or a propagule, which is a material that can be separated from a plant and help in generating a new plant. Extant variety includes farmer's variety, or the one which is commonly known or which is available in public domain. Farmer's variety as per Section 2L is the one which is cultivated and evolved by the farmers in their fields over a period of time. The wild variety of a variety or a land race means the ones which cannot be kept on a farm, which cannot be domesticated. They are wild. The farmer should have the common knowledge of it. Section 39 provides for the farmers' rights, where the farmers get the right for the mentioned activities such as saving, using, exchanging, sharing, or selling the variety. Transgenic variety is where the genes are modified through the engineering by adding some other unrelated genes or removing the faulty genes. Essentially derived variety is explained in Section 2I, which explains essentially derived variety, which means the one which is derived or obtained from the initial variety, where the expressions of essential characteristics are retained resulting from the genes or combination of genes of the initial one. It should be distinguished from the initial variety and conform to the initial variety apart from the difference that may be prevailing in the derived variety. As per section 14, the applicant can file an application for registration of genera, that is the genus of a variety, as in taxonomic rank, as we have discussed earlier. The species, which means that the unit which has the capacity of interbreeding, extant variety or farmer's variety. As per section 15, any new variety can be registered if it is novel, that is new, which means the harvested material of such variety or propagating material, that is the breeding stock of that plant, is not sold in India or otherwise before. It must be distinctive, that is, at least one characteristic must be such that it helps to distinguish the variety from the previously registered variety or commonly known variety. It must have sufficient uniform essential characteristics if there are changes expected. It must be stable, that is, after the repeated breeding or propagation or at the end of the process, it should remain stable. Section 15 clause 4 provides for which new variety cannot be registered. If the mark cannot be identified or consists only of figures or misleads or confuses the public as to the variety or the breeder, or if it is not different from the mark of the other variety of the species or closely related species, or if it cheats the public or hurts the religious sentiments, it is prohibited by Emblems and Names Prevention of Improper Use Act of 1950, or if it is a geographical name, it cannot be registered under this act. The application for registration should be as per section 18, wherein it should be clearly mentioned which variety it is for, the denomination, that is the letter, combination of letters and figures in any language as per section 2G of the act, which should not be registered under Trademarks Act of 1999. An affidavit that it doesn't have a gene or a gene sequence that involves terminator technology, that is on and off switches, contain description of parental line, how it evolved in case of derivative ones. The statement of novelty, distinctiveness, uniformity and stability explaining it. The declaration of lawful breeding and proper fees must be paid. The application is filed in the office of registrar. According to section 20, the registrar can accept the application fully or conditionally, or he can refuse it. In case of rejection, an opportunity is given to the applicant to put his case and explain why it should not be refused. On acceptance, the registrar advertises it, or we can say he publishes the same according to section 21, for if anyone has opposition to the registration, they can file it within 3 months by giving such notice. As per section 19, enough quantity of seeds must also be given to the registrar with the application so that tests can be conducted with its parental material and it is seen if it conforms to the legal standards. The registrar gives the certificate of registration to the applicant as per section 24 with the seal of registry, and the copy is also sent to the Authority of Plant Varieties and Farmers' Rights. They determine how will be the benefit sharing. Benefit sharing is explained under section 2B as the proportion of benefit that a breeder shall get from his agent or the licensee, and it is determined as per section 26 by the authority. The certificate for essentially derived varieties is given under section 23. The advantage of registration is that it provides the exclusive right to the breeder, his successors, agent and licensee under section 28 to sell, produce, market, distribute, import or export the variety. In case of extant variety, the breeder or his successor has to prove and establish their rights, and until then, the central government or the state government is the exclusive right holder as per the Seeds Act of 1966. Registration gives the right to license the rights. Registration is the conclusive proof of the terms of the registration. Section 31 provides for the international protection where any convention, treaty or agreement is signed by India Similar privileges and rights are offered as that of the native in all these countries. Section 24 provides for the terms of registration, which is 9 years in case of trees and vines and 6 years in case of other crops. The maximum protection offered is 18 years for trees and vines, 15 years in case of extant variety from the date of central government notification, and in all the other cases, it's 15 years from the date of registration. After this, it falls under the public domain. Section 27 mandates the breeder to deposit the seeds and propagating material in the National Gene Bank for reproduction at their own cost. As per Section 39, the farmers can claim compensation from the breeders if the propagating material is sold to them with an assurance of a particular result and it fails. Such complaint is made to the authority and the authority gives the opportunity to both the parties of being heard. Section 41 gives the community right where the claim can be made by the people of a village where they have made contributions for the evolution of that variety against the breeder and such complaint is made to the authority and the parties are heard. Compensation can be claimed from the breeder, which is to be deposited in the gene fund constituted under Section 45 of the Act to deal with all the money related matters, all the give and take, made benefit sharing or fees or compensation. Section 42 protects the innocent infringers who did not know that the variety is a registered variety. It is an infringement under this Act if the person who is not the breeder or his registered authority does any act provided in this Act for commercially exploiting the rights by using, selling, importing, exporting, producing the variety or makes a deceptively similar variety, causing confusion related to the identity. It is an infringement as per Section 64. Section 65, the suit against the infringement is to be filed with the district court. The reliefs under Section 66 are injunction with ex parte interlocutory order, discovery of documents, attachment of property, damages, and costs. It is an offense to sell the variety by falsely applying the denomination mark, where the penalty as per Section 70 is imprisonment from 3 months to 2 years or fine of rupees 50,000 to 5 lakh rupees or both. The punishment for selling such variety is 6 months to 2 years, imprisonment or fine 50,000 rupees to 5 lakh rupees or both as per Section 71. For falsely representing the registration under Section 72, it is imprisonment for 6 months to 3 years or fine rupees 1 lakh to 5 lakh rupees or both. For subsequent offences, it is imprisonment for 1 year to 3 years or fine 2 lakh rupees to 20 lakh rupees or both as per Section 73. As per the tribunal reforms of 2021, the appeal is to be made to the High Court in all the cases by filing a written petition. Some of the registered varieties in India is Pusa Panna, Pusa Prabhat, Prakash and others denominations for field pea in extant variety, Pratap hybrid maize and Gujarat Makai for maize crop in extant variety, Kashipuram for French beans. These are some important provisions related to the plant varieties and farmers' rights in India. Thank you.